Hello, my name is Professor Shiladitya Rakshit. The problems of international and internationalized armed conflict. Brief overview. This module provides an overview of the distinctions between the types of armed conflicts that exist under the international humanitarian law. Further, it discusses the emergence of international armed conflict and various provisions that exist under the laws to determine the internationalization of an armed conflict. The module contains examples of recent internationalized armed conflicts. Further, it establishes the difference between the effective control test and the overall control test of determining the internationalization of an armed conflict. Learning objective. The objectives of this module is to make the readers understand the difference between the three types of armed conflicts. Also, the module aims to establish a fine distinction between international and internationalized armed conflicts by way of various judgments and law. The module also aims to make a clear distinction between the overall control test and the effective control tests and the utility in the current scenario. Introduction. With the rise of globalization and international treaties, the interaction between different states of the world is increasing. The world is more aware of what is happening around them. Motivations for intervention in civil wars may have changed since the end of the Cold War, but with the increased economic independence of states born of globalization, the development of nuclear capabilities amongst previously incapable states, the greater incidence of terrorism in Western countries, and the increasing scarcity of natural resources all provide continuing incentives by foreign intervention in domestic conflicts. As a result, a third perspective of armed conflict, that the international armed conflict, has been added to the existing international and non-international armed conflict. Definition. Before moving further, it is important to understand the definition of each type of armed conflict under the international humanitarian law. The International Committee of Red Cross has defined the internal and international armed conflicts in the following ways. The international armed conflict exists whenever there is a resort to armed force between two or more states. Non-international armed conflict is protracted armed confrontations occurring between governmental armed forces and the forces of one or more armed groups, or between such groups arising on a territory of a state party to the Geneva Convention. The armed confrontation must reach a minimum level of intensity, and the parties involved in the conflict must show a minimum of organization. Although the international humanitarian law has made distinction between the types of conflict, one question remains to be answered: the question of addressing those armed conflict which had elements of both international armed conflict and international armed conflict. International armed conflict and internationalized non-international armed conflict is a civil war characterized by the intervention of the armed forces of a foreign power. There is no specific provision in the international humanitarian law to deal with the internationalized armed conflicts. Difference between the two. The international armed conflict is between the states. On the other hand, the internationalized armed conflict is achieved by the instant intervention of the second state in the ongoing internal crisis of any state. The involvement of the second state in the internal conflict, however, cannot always lead to the internationalization of a non-international armed conflict. For example, the conflict between the state of Afghanistan and the terror group Taliban does not become internationalized by the US, UK or NATO forces. This is because the US, UK and NATO forces were allies with the government in fighting against Taliban and did not play a role of second state. The Geneva Convention of 1949 and additional protocols of 1977 consists of 600 articles, out of which only the common Article 3 and the 28 articles of the additional protocol 2 are applicable to the internal armed conflicts. Rest all other guidelines and rules are for the international armed conflict. On the other hand, there is no provision for the internationalized armed conflicts. How does NIAC gets internationalized? The factual circumstances that can achieve the internationalization are numerous and often complex. The term internationalized armed conflict includes war between two internal factions, both of which are backed by different states. Direct hostilities between two foreign states and military intervene in an internal armed conflict in support of opposition sides, and war involving a foreign prevention in support of an insurgent group fighting against an established government. In the TADIC appeal judgment, the appeal chambers of the ICTY, International Criminal Tribunal for former Yugoslavia, stipulated that it is indisputable that an armed conflict is international if it takes place between two or more states. In addition, in case of an internal armed conflict breaking out on the territory of a state, it may become international if another state intervenes in that conflict through its troops. Alternatively, if some of the participants in the internal armed conflict act on behalf of that other state. The above condition set by the ICTY provides conditions for the internal armed conflict to become international. In the same case, the ICTY provided the overall control test to determine the internationalization of an armed conflict. The TADIC appeal judgments test to determine the internationalization of internal armed conflict is sum of the participation in the Internal Armed Conflict Act on behalf of an other state. It says that the overall control of any rebel group going against the state would be sufficient to internationalize the armed conflict. The standard is satisfied if any state outside the territory has a role in organizing, coordination and planning the military action. Another way in which a conflict can become international is provided in Article 1, Paragraph 4 of Additional Protocol 1977. It says, when the conflict occurs between the state party and an authority representing its people against colonial domination and foreign occupation, and against the racist regimes in the exercise of the right of people to self-determination, such conflict becomes international. According to Marko Milanovic, Secretary General of European Society of International Law, there are only two situations where, with the intervention of a second state in the NIAC between a state and non-state actor, the conflict is internationalized. State A intervenes into the internal conflict of State B in support of the non-state actor and against the State B. 2. State A acts against the non-state actor present in State B without the permission of State B. Situations where a State A would act against the non-state actor present in State B alliance with State B will not be termed as an international armed conflict. IHL timeline, April 24, 1863. The Liber Code was introduced. It was a field manual instructing the US Army on how to behave in the war. October 26-29, 1863, International Conference is held in Geneva to discuss the laws of war proposed by Henry Dunant. August 22, 1864, Convention for the Amelioration of the Condition of the Wounded in Armies in the Field adopted, Geneva. This is the first Geneva Convention. July 29, 1899, International Peace Conference is held at The Hague, which leads to the birth of various Hague Conventions. August 8, 1945, the Allied powers of World War II create an international military tribunal to prosecute Nazi war criminals in Nuremberg, London. November 21, 1945, some 21 Nazi leaders are prosecuted for crimes of aggression, war crimes and crimes against humanity in Nuremberg. 11 are sentenced to death, 3 are acquitted and the rest are imprisoned. October 1946, in the wake of the precedent set by Nuremberg, International Congress is convened in Paris, calling for the adoption of an international criminal code prohibiting crimes against humanity and the prompt establishment of an International Criminal Court or ICC. December 10, 1948, the UN General Assembly adopts the Universal Declaration of Human Rights, detailing human rights and fundamental freedoms. August 12, 1949, another diplomatic conference is held in Geneva, establishing Convention 1 for the amelioration of the condition of the wounded and sick in armed forces in the field. Convention 2 for the amelioration and condition of wounded, sick and shipwrecked members of the armed forces at sea. Convention 3 relative to the treatment of prisoners of war. Convention 4 relative to the protection of civilian persons in times of war. June 8, 1977, additional protocols of the Geneva Convention are adopted, one in relation to the protection of victims of international armed conflicts, two relating to the protection of victims of non-international armed conflicts. October 10, 1980, a UN conference in Geneva establishes prohibitions on the use of certain conventional weapons which may be deemed to be excessively injurious or to have indiscriminate effects. Protocol on non-detectable fragments, protocol on prohibitions or restrictions on the use of mines, booby traps and other devices. Protocol on prohibitions or restrictions on the use of incendiary weapons. December 10, 1984, the UN General Assembly adopts the Convention against torture and other cruel, inhuman or degrading treatment or punishment. May 25, 1993, the UN Security Council establishes an International Criminal Tribunal to prosecute war crimes in the former Yugoslavia. November 8, 1994, the UN General Assembly establishes a second International Criminal Tribunal to prosecute war crimes in Rwanda. June 17, 1998, Rome Statute establishes the International Criminal Court is finalized and adopted. International Criminal Tribunals and the ICC. Ad hoc courts of limited jurisdiction. The Nuremberg and Tokyo Tribunals, International Criminal Tribunal on Rwanda. International Criminal Tribunal on the former Yugoslavia, Sierra Leone, Timor-Leste, Cambodia to ICC. Expansion in time, a permanent court. Expansion in space, not limited to regions. And then the US war on terror. On September 11, 2001, 4 domestic commercial aircraft were hijacked by 19 men from 3 airports on the east coast of USA. The hijackers were identified as men from the organization Al-Qaeda. 2 of the airplanes were deliberately flown into the World Air Trade Center in Manhattan, New York. As a result, both of the towers collapsed. Around 3/4 of an hour following this attack, the Pentagon building in Washington, D.C. was struck by another of the airplanes. About 15 minutes later, the 4th hijacked airplane crashed into the field of Pennsylvania. Following this attack, the then US President George W. Bush stated that America was in a war on terrorism. A resolution dated 18 September 2001 was passed by the US Congress authorizing the President to use all necessary and appropriate force against those nations, organizations or persons he determines planned, authorized, committed or aided the terrorist attack that occurred on September 11, 2001. On October 2001, the United States, in conjunction with NATO, began airstrikes against the Taliban regime authorities in power in Afghanistan. By 2003, the war on terror had spread to include Iraq and the regime of Saddam Hussein, whom they suspected was hiding the suspected terrorists and Al-Qaeda operatives. US also had instituted policy of retention of the persons arrested in retaliation to the war on terror. Bulks of foreign detainees were taken to the US military base in Guantanamo Bay in Cuba. The then US government also tried to limit the protection and remedies offered to detained persons. Both US law and international law was challenged by the detainees a number of times. In HAMDAN versus RUMSFELD, Salim Ahmed Hamdan worked under Osama bin Laden in Afghanistan. During the US invasion of Afghanistan in 2001, he was captured by the US Army and put in Guantanamo Bay detention camp. In Hamdan versus Rumsfeld was the case filed by Hamdan for his liberty and release from Guantanamo Bay as per the Geneva Convention. In the court, the Bush administration argued the Geneva Conventions will not apply as the US conflict with the organization Al-Qaeda did not qualify as either an international armed conflict or a non-international armed conflict. The common Article 3 states that article applies to armed conflicts not of an international character occurring in the territory of one of the high contracting parties. The Bush administration justified the detention of Hamdan by stating that the common Article 3 does not apply a situation as the conflict with Al-Qaeda being international in scope, does not qualify as a conflict not of an international character. The Supreme Court rejected the argument and said that at minimum common Article 3 applies to the conflict with Al-Qaeda. Article 3 to all 4 Geneva Convention provides that in a conflict not of an international character occurring in the territory of one of the high contracting parties, each party to the conflict shall be bound to apply as a minimum certain provisions protection persons taking no active part in the hostilities, including members of armed forces who have laid down their arms, and these placed hors de combat by detention. One such provision prohibits the passing of sentences and the carrying out of executions without previous judgment, pronounced by a regulatory constituted court, affording all the judicial guarantees which are recognized as indispensable by civilized peoples. The decision was based on the idea that US is a high contracting party to the Geneva Convention. Its conflict with Al-Qaeda is taking place in a territory of a high contracting party, as Afghanistan is also a party to the Geneva Convention. The US is fighting against a non-state group, Al-Qaeda, rather than another state. The US conflict with Al-Qaeda is a non-international armed conflict, and common Article 3 applies. From the ruling of the Supreme Court in the HAMDAN versus RUMSFELD, it can be implied that the common Article 3 should be applied universally to all the conflicts as a set of basic fundamental rules to be observed in armed conflict, provided that the conflict takes place in the territory of a party to the Geneva Conventions. Tests to determine internationalized armed conflict. International Court of Justice ICJ in the Republic of Nicaragua versus the United States of America determined the responsibility of the United States for armed conflict between the Contraist had sponsored and the Nicaraguan government to define the circumstances in which an insurgents acts can be attributed to a state. The court applied what it described as an effective control test, which involved assessing whether or not the relationship of the Contras to the United States government was so much one of dependence on the one side and control on the other, that it would be right to equate the Contras for legal purposes with an organ of the United States government or as acting on behalf of that government. However, the Tadic appeal judgments overruled the trial chamber's support for the strict effective control test espoused in the Nicaragua case. The overall control test was developed. According to the overall control test, the following points had to be proved to show that the conflict was internationalized. 1. Where the question involves the acts of a single private individual or a not military organized group that is alleged to have acted as a de facto state organ. It is necessary to ascertain whether specific instructions concerning the commission of that particular act has been issued by the state to the individual or group in question. Alternatively, it must be established whether the unlawful act has been publicly endorsed or approved ex post facto by the state at issue. 2. The control by a state over the subordinate armed forces, militias or paramilitary forces required that a state has a role in organizing, coordination or planning the military actions of the military group, in addition to financing, training and equipping or providing operational support to that group. By that does not go so far as to include the issuing of specific orders by the state or its direction of each individual operation. Third, the third requirement of the test was assimilation of individuals to state organs on account of their actual behavior within the structure of a state. Thus, the test of effective control prescribed by the International Court of Justice in the Republic of Nicaragua versus the United States of America was overruled. The current status determine whether an internal armed conflict is internationalized is determined through the overall control test given by the prosecutor versus the Tuscan Tadic. Thank you.